Kibe Mungai, on behalf of the petitioners. There are two issues. You can see the senior, the team leader, Honorable Paul Ruto is not with us in the council. That is the first thing that we deal with it in the afternoon. And as far as we are concerned, the matter is premature and the hearing and determination of that applications for the simple reason that the issue and an order had already been made that would be first dealt with by the court after its ruling of yesterday. It was the application for recusal. The other matters that relates to how we shall deal with the petition, and we shall deal with all the applications, including the first application for conservatory orders. Those are matters that, as far as we are concerned, are supposed to be dealt with by the directions. By this bench, if it continues, or by any other bench. And therefore, the issue, my lord, of a back and forth on what is to be had first, the court has already ruled on that. And I believe we need to stick to that. And I am lamenting that even as we sat here, because we have started a little bit late, there is some work we still needed to do with regard to the applications for the afternoon. So we would like any other businesses that is supposed to be done when, for example, Paul Multe is in the afternoon, it will be dealt with in the afternoon. But my lord, on the directions, the actual directions that have been given by the court, there are three things actually that we would like our reactions on behalf of the petitioners. Number one, my lord, is that in giving these directions, we are understanding that the directions are being made pursuant to the rules of procedure that are applicable. My lord, under the rules of procedure that are applicable, a lot of the petitions that were filed before last Friday and the ones that were filed even on Friday last week are maturing their last dates for responses. My lord, as we sit here, we are yet to receive any substantive responses to those petitions in either boards from the respondents. And that will have an impact on how soon we can be able to deal with the substantive matters. So, my lord, I would be expecting that as a further directions, everybody would be required also to comply with the Mutunga rules to the full. Now, the second issue is that in all the petitions, the subject matter was the impeachment proceedings. The impeachment proceedings was culminating with the impeachment that was done last Thursday and the facts as they happened on Friday. A lot of these petitions would require some amendment so that they conform with the last petition, so that they are not termed as academic. So that, my lord, towards that, the petitioners, including in the petitions where I'm participating, we have requested formally that we would want 3 days to ensure that any amendments are carried out. And then the respondents will indicate, they have been saying they can do things within a day or two. They will indicate how much time they need to do the responses, because, my lord, that would assist in ensuring that whichever bench is going to hear and determine this matter would be able to give final directions, because, as we have said, these are interim directions. And number three, in order to be able to determine issues for determination, and these are issues that we deal with when we are doing pre-trial, issues for determinations that are essential in a matter with so many parties, that would require clause of pleadings. And the clause of pleadings means that all the responses must be given. So that, my lord, as far as today is concerned, I urge you respectfully that the first thing that can ensure we are moving forward is to ensure that the responses, in accordance with the Mutunga rules, will complete that journey. My lord, if that is done, it is my view that we will be able to make some progress. In the meantime, my lord, unless there is any other matter, because there was no other matter that was to be dealt with except directions, we would be happy to leave this place as soon as possible so that we are ready in the afternoon. We are most obliged.
Just before leaving.
I think because I'm on the same side, perhaps so you can have some response on it. Your Lordship, for purposes of clarity and for purposes of not addressing the gallery anymore, permit me to draw the attention of counsel for the Senate to the notice of motion that was filed in respect to the conservatory orders that were granted. The judge sitting in Kiruga, Your Lordship, was categorical that he granted prayer number C. Even as we await senior counsel Paul Mojo to come in the afternoon, the wording of those prayers was so explicit that if my good professor had the opportunity of interacting with the document, which I believe he has not, would have come to the conclusion that the orders were drafted in this manner. That pending the hearing and determination, of this application inter parties, this Honorable Court be pleased to grant the orders that were granted. That is therefore to mean, Your Lordship, that question that senior counsel was raising has no sitting in the pleadings before you. Number two, Your Lordship, since we are here for mention and in the afternoon we are coming for the application for recusal, and I have had the advocates for the respondents insisting on the urgency to hear the application for setting aside, Your Lordship, it is important for the court to note that that application is not predicated on any response. And therefore, if I were them, I would be seeking guidance on how to file their replies. Your Lordship, I hope you are following.
Following.
He doesn't seem to be following.
Why do you say that?
But
Why do you say that?
let me leave it at that.
Thank you. I think that is, sorry, gentlemen, you cannot talk forever.